So good afternoon for some of us and good morning for others. Thank you so much for joining us today for the latest webinar from the American Bar Association Civil Rights and Social Justice section, brought to you by our Civil Rights and Equal Opportunity Committee. I bring greetings from our section chair, Wendy Mariner, and the Civil Rights and Equal Opportunity co-chairs, Jamie Hawk and Kathleen Yonohara. Thanks also to Drusilla Ramey for helping to make this webinar possible. My name is Janelle George. I'm also a co-chair of the Civil Rights and Equal Opportunity Committee, but today I'm speaking in my personal capacity. And I really want to underscore today that the views expressed herein have not been approved by the House of Delegates or the Board of Governors of the American Bar Association, and therefore accordingly should not be construed as representing the policy of the American Bar Association. These views are the views of the individuals themselves in their personal capacities. And today's webinar features leading civil rights lawyers who will discuss the long-standing disparate impact legal theory, which has been a crucial civil rights legal tool used to expose and address the most covert and pervasive forms of discrimination and to uphold civil rights in a wide range of areas of life, including housing, education, employment, healthcare, the environment, transportation, and criminal justice. So we know that some of you are still logging on, but we do want to get a sense of who you are as well. So if you can we'll take about a minute, and if you can fill out the poll question that should be appearing on your screen, and it will ask you, are you a, and you can indicate your identity. So we'll give you about a minute to fill this out. Great, wow. So it looks like the majority of participants are nonprofit attorneys, followed by advocates or interested members of the public, followed by government attorneys, law students, welcome, and law firm attorneys. Welcome to everyone. Thank you so much for joining us today. So today we will begin with an introduction of our speakers. And you will see in your handouts, the first handout has much more detailed bios of today's speakers. And then we'll hear about the historical significance of disparate impact and as throughout the decades of civil rights litigation. Our panelists will discuss disparate impact in the housing context and how a rule that has recently been proposed by the administration may impact efforts to remedy housing discrimination. We will also hear from today's panelists about the significance of disparate impact in addressing gender-based discrimination and discrimination against individuals with disabilities. We will provide in some of our closing slides links to resources and information for those who are interested in submitting comments on the proposed rule. At the very end, after our panelists present, we will also open up the forum for questions. You can ask questions of our panelists by finding the question drop box, which is also in your menu, right above the poll. On the right side, hand side of the panel. You will type in your question and we will address your question. Please note that we'll consolidate the questions that are similar. So your question might not be phrased exactly as you have typed it or input it. We'll also be sharing a recording of this program to everyone who is registered so that you can share it widely with your, and we encourage you to share it widely with your networks. And please feel free to leave us feedback or any questions for follow-up. So it is now my pleasure to introduce to you what is really an esteemed panel of the Civil Rights Bar. Again, you can read the more detailed bios of today's panelists in the handout attached, but right now I'll share some very brief introductions. We have first Eva Patterson, who is a co-founder and president of the Equal Justice Society. If you can wave, Eva. A legal organization that works to transform the nation's conscience on race through law, social science, and the arts. And she will discuss a historical context and framing of disparate impact as a civil rights legal tool. She will be followed by Leslie Pearl, if you can wave Leslie, who is a leading civil rights champion who currently advises the National Fair Housing Alliance. She will discuss disparate impact in the housing context and also address some prior case law. We will then hear from Lisa Kyler Barrett, who is the Director of Policy at the NAACP Legal Defense and Educational Fund, or LDF. Thanks for waving, Lisa. In this capacity, she leads and manages all of the policy efforts across LDF's 4 impact areas: education, criminal justice, civic participation, and economic justice. She will discuss how the proposed rule may impact efforts to address housing discrimination, and she'll talk more in detail about some of the changes that the proposed rule would make. We will then hear from Sandra Park, who, and you can wave Sandra as well, who is a senior attorney with the American Civil Liberties Union, or ACLU's Women's Rights Project. Her work at the ACLU focuses on advancing gender equality and challenging discrimination experienced by survivors of gender-based violence. She will discuss the implications of changes to the disparate impact standard for survivors of domestic violence, as well as other efforts to address gender discrimination. And last but definitely not least, we will hear from Jennifer Mathis, who's Director of Policy and Legal Advocacy with the Judge David L. Bazelon Center for Mental Health Law. In this capacity, she engages in litigation and policy advocacy to promote community integration of individuals with mental disabilities and engages in other work addressing discrimination against individuals with disabilities. She will discuss disparate impact and its significance in the context of discrimination impacting individuals with disabilities. And at this time, we'll hand it over to Eva Patterson, who will start us off in today's discussion.
Good morning. I'd like to place this whole discussion in a historical frame. This summer, we commemorated the landing of 20 enslaved Africans at Jamestown, starting the whole discussion that culminated in the brilliant piece in the New York Times, the 1619 Project. And what we have been looking at as my organization is how legal jurisprudence has been affected by the struggle of enslaved people for freedom. So we had a civil war, and after the Civil War, a number of laws and statutes and amendments were passed to try to remedy some discrimination. You had, though, a pushback on a political level with very conservative people trying to stop Reconstruction, and with a Supreme Court that was very much dominated by corporate interests, very much limiting the reach of these post-Civil War statutes. You then had a struggle over many decades for equality, culminating in the on-the-ground civil rights struggles in the 50s and 60s, the March on Washington, which led to landmark legislation in the Civil Rights Act of 1964, which led to Title VII, which dealt with employment discrimination, and Title VIII, which dealt with housing discrimination. And the early law that came out of the Supreme Court was very, very good. And it's almost a relic to think about the fact that there were Republican judges on the Supreme Court who put forth the notion that if there are statistical disparities, for example, in hiring practices, let's say you have 100 Latinos applying for a job and 100 white people applying for a job, every white person gets the job, one Latino gets the job. That statistical disparity is enough to start the inquiry at the court that will lead to a finding of liability and goals and timetables being set up. There was no discussion at all of having to prove that the discrimination was intentional, just showing the disparate impact was all that you needed to do. So we fast forward from the early 1970s to 1980, the Reagan-Meese Justice Department. And it's very important that you pay attention to this and connect the dots. The Meese Justice Department in 1980 wrote a paper called The Constitution in the Year 2000. They were projecting ahead 20 years. One of the key parts of that document was to say, we want to undermine and eliminate the disparate impact standard and replace it with the intent standard. So this is what they were cooking up in terms of jurisprudence in 1980. That was the same year that the Federalist Society was founded, creating a pipeline for conservative folks from the law schools to clerkships to the federal bench. So you had this conflict in terms of disparate impact and intent, which was a kind of a philosophical struggle. So there was a case that people will talk about later on this call that was up at the Supreme Court, challenging the fact that the disparate impact standard was used in housing cases. All the courts of appeals had decided that the disparate impact standard was right, but the right wing very strategically decided they wanted to go up to the Supreme Court and try to get the intent standard put back in place. I won't steal the thunder of other panelists who are going to talk about this, but we won that battle. Now the forces of conservatism, the forces of the right wing are trying to get the intent standard put back in place at HUD. People will talk about that a little bit more. The point I wanted to make today in my comments is that this is part of a struggle about how our society is going to eliminate racism. Most intelligent people, in my humble opinion, think you shouldn't have to show intent to make out a showing of discrimination. Heck, the Ku Klux Klan says that they aren't racist. So if they aren't even admitting to the fact that they are intentionally discriminating against people of color, what chance do we have in making that case against corporations or housing complexes or the like? So it's important to understand that this is more than just a discussion about a legal doctrine. It's about how our nation is going to fight and eliminate racism. We're now at a point in our nation's history where white supremacy is on the rise again, racism is on the rise again. It's a rather sad point in time, but this particular webinar will give people tools to hold the line and to keep the hands of the clock of America moving forward. Our next speaker will be the fabulous Leslie Prohl, who knows so much about everything and is a warrior and a hero. So, Leslie.
Thank you so much, Eva. And let me first give a shout out to Janelle, George, and team. This is a great opportunity to talk about a really important issue. And as a former co-chair of the Civil Rights Committee, I really appreciate you taking up this mantle. Eva talked about the long history of this doctrine, and I think that's really important to know for this discussion today. This is a concept, and I hope you understand what we're talking about here. We're talking about neutral policies that they don't necessarily reveal discrimination on their face. They're neutral policies that disproportionately affect protected classes under the civil rights laws. And this concept was embedded into the law almost as early as the civil rights statutes were first passed. You had the 64 Civil Rights Act, you had the 68 Fair Housing Act. Very soon after that, the Supreme Court decided a case called Griggs versus Duke Power Company that recognized the concept of disparate impact in the employment discrimination context. Almost immediately, courts began to apply this concept under the Fair Housing Act, which had just passed. And it really is today the most important tool that we have to address structural inequality and the residential segregation that still persists 50 years after the Fair Housing Act. And what's happening now at HUD is something that should concern all of us, and it very much could weaken this critical tool that we have to fight discrimination. Wanted to talk to you a little bit about the first case that was recognized by the appellate courts under the Fair Housing Act, because I think it's a very good example of how disparate impact is used. And some of these cases, sadly, have fact patterns that are not dissimilar to the United States versus City of Blackjack case. This was a situation in St. Louis in the early 70s where an interfaith organization decided it wanted to build some affordable housing in the outskirts of St. Louis for St. Louis's African American population. This was in an unincorporated area, and it was populated by mostly white people. And what happened is when that community got wind of the plan to build housing, the unincorporated community decided to incorporate. And the first action they took as a municipality was to pass exclusionary zoning, which blocked this affordable housing. The Justice Department under the Nixon administration filed the lawsuit, and it was the first time that a circuit court had recognized this concept of disparate impact under the Fair Housing Act. So it's a very important seminal case. After that, every circuit court that considered the issue ruled that disparate impact is cognizable, feasible under the Fair Housing Act. And this was over decades. You had courts ruling this way and then interpreting the law and creating what we call a burden shifting test for how you prove discrimination under the disparate impact case. In 2013, the Obama administration decided to memorialize that test in federal regulations and issued a final rule from HUD on disparate impact. And it basically used the case law that was out there and came up with the test and put that in the federal regulations. In 2015, as Eva said, the Supreme Court heard a disparate impact case for the very first time. You had decades of lower courts interpreting the Fair Housing Act to include disparate impact, but the Supreme Court had never decided it. 2015, it did. And it said that disparate impact was definitely cognizable under the Fair Housing Act. The case was Texas Department of Housing and Community Affairs versus Inclusive Communities Project. It's a very long title, but the court affirmed that disparate impact was available under the Fair Housing Act. This was a fair housing case brought out of Dallas, which sued Texas for the way that it allocated low-income housing tax credits. They were approving the tax credit funding in predominantly minority areas and not approving it in white suburban areas, therefore, or thereby perpetuating the segregation of the Dallas residential community. And so that is the case that went up to the Supreme Court. In an opinion by Justice Kennedy, the court examined the statutory history of the Fair Housing Act and relying upon the Griggs case and the analysis under Title VII, the Fair Employment Act, it looked and found in the Fair Housing Act similar language and similar intent that Congress was trying to get at consequences, at results, not just intentional discrimination when it passed the Fair Housing Act. And importantly, the court acknowledged that disparate impact is consistent with the central purpose of the Fair Housing Act. And I wanted to read what I thought is an important statement from the court. The recognition of disparate impact liability plays an important role in uncovering discriminatory intent, which is what Eva was getting at. It permits plaintiffs to counteract unconscious prejudices and disguised animus that could escape easier classification as discriminatory intent. So it was a very seminal ruling, and it was the right outcome. Obviously, a lot of us believe that. Fast forward to today, and we have the Trump administration trying to undo essentially what the Supreme Court refused to do, and that is to severely gut the disparate impact test. Lisa Kyler-Barrett is going to talk about the differences in the proposed rule versus what the final rule contains right now. They are stark, and it essentially would gut the Fair Housing Act's disparate impact standard. want you to leave this seminar knowing that this is a widely used tool. This is not something that is invoked in only certain circumstances. It applies to every protected class under the Fair Housing Act, and I hope you know that that's race, national origin, gender, religion, disability, and families with children. But in exclusionary zonings, absolutely, disparate impact applies, and it's kind of exclusionary zoning, 21st century style. And the case that I talk about there is the St. Bernard Parish case, where after Katrina, a parish in Louisiana decided it was going to limit who could rent owner-occupied homes. A lot of people were leaving New Orleans and looking for housing outside of New Orleans. So this parish passed an ordinance that said you can only rent an owner-occupied home if you're a blood relative of the owner. And so this effectively excluded African Americans in Louisiana from doing so, because 93% of the residents of St. Bernard Parish were white. That was a disparate impact case. Discriminatory mortgage lending absolutely relies on disparate impact. Higher fees and rates charged to African Americans and Latinos in the name of risk aversion and increasing reliance on algorithms mask that type of prejudice. So that's a very important place where this is used. Insurance premiums, homeowners insurance, limiting homeowners insurance to in areas that are predominantly minority. And also there was a DC case that I thought was interesting, where they limited the homeowners insurance for an apartment complex that actually rented to people who used housing vouchers. That was a disparate impact case that was brought because of the race of the tenants who were using the apartments. Immigration status, there was a recent case out of Virginia where a mobile home park decided that in order to renew your lease, you had to suddenly provide evidence of documentation. And so it disproportionately affected Latinos who were living in that. That was a disparate impact case. Families with children, the occupancy standards that are imposed on apartment complexes for 2 persons per bedroom. There are cases where people find out they're pregnant and tell their landlord, and they're suddenly subject to eviction because you're not supposed to have a baby in a 2-person bedroom. You will hear more examples on the use of this by women and persons with disability, but suffice to say that this is widely used all over the country, has been for decades, and it's up to us to try to protect it now. Thank you. And I'm going to turn it over to Lisa Kyler-Barrett from the LDF, who's going to talk about the intricacies of the new proposal.
Thank you so much, Leslie, and thank all of you for joining this important conversation today. I'm so honored and pleased to be a part of this discussion with all of my esteemed colleagues. As Leslie said, my name is Lisa Kyler-Barrett. I'm the Director of Policy at the NAACP Legal Defense and Educational Fund. And for nearly 80 years, LDF has pursued racial justice in education, economic justice, political participation, and criminal justice. And as part of that advocacy, LDF seeks to ensure the enforcement of civil rights laws and the Constitution's guarantee of equal protection. And our participation in this conversation today, we see as a critical part of that effort, because we believe that the disparate impact standard is a critical tool to combating discrimination, and are astonished at the effort to eliminate that tool. As Leslie shared, just 4 years ago in the Supreme Court case, Texas Department of Housing and Community Affairs versus Inclusive Communities Project, Justice Anthony Kennedy wrote, quote, "The Fair Housing Act must play an important part in avoiding the Kerner Commission's grim prophecy that our nation is moving toward 2 societies, one black, one white, separate, and unequal, unquote. In that case, as Leslie shared, the court acknowledges that the Fair Housing Act's continuing role in moving the nation toward a more integrated society. And the message from Justice Kennedy was clear 4 years ago, and it remains clear today, that all Americans should continue to be protected from housing discrimination. And it's with that backdrop that it's especially disturbing that we see this administration put forth a rule that will effectively eliminate HUD's use of the disparate impact standard. Again, a critical tool in advancing the mission and purpose of the Fair Housing Act. The decision to gut the disparate impact tool would have a deeply and profoundly negative effect on the housing choices of millions. Keeping the standard intact is essential to fully realizing the intent and promise of the Fair Housing Act and to fulfilling HUD's stated mission to create inclusive and sustainable communities free from discrimination. So let's talk a bit about what's actually in the rule, the proposed rule. First, I just wanted to give you a bit of a comparison of what's in the current rule, that is the rule that was finalized, excuse me, in 2013, and then what's in the proposed rule. So under the current rule, it really embodies what you've heard both from Eva and Leslie in terms of the case law, decades of case law, and the practice of what is necessary to establish a prima facie case. So under the current rule, a plaintiff can establish a prima facie case by demonstrating, that the practices are cause a discriminatory effect on a group of persons or a community on the basis of race, color, religion, sex, disability, familial status, or national origin. That would establish a prima facie case under the existing rule. Under the rule that's being proposed by HUD, there would be a huge barrier or a huge hurdle for folks to climb to even establish a prima facie case. So if you look at what's on the right side of the slide that's currently on the screen, there would now be a 5-step process to establishing a prima facie case. And it's not that a plaintiff needs to prove one of those. They need to prove all 5 of these, establish all 5 of these. So a plaintiff would have to show that the challenged policy or practice is arbitrary, artificial, and unnecessary to achieve a valid interest or legitimate objective. And they would have to show that there's a robust causal link between the challenged policy or practice and a disparate impact on members of a protected class. And they would have to show that the alleged disparity caused by the policy or practice has an adverse effect on members of a protected class. And they would have to demonstrate that the alleged disparity is significant and that there's a direct link between the disparate impact and the complaining party's alleged injury. So just to establish a prima facie case, they would have to prove all 5 of these elements. And if you know anything about discrimination litigation, that's a pretty high bar and would effectively make it very difficult, if not impossible, for folks to be able to establish a prima facie case. Next slide. So under the current rule, once a prima facie case is established, we have the burden shifting that you heard both Eva and Leslie talk about. So it would move to the defendant to prove that the practice is necessary to achieve one or more substantial, legitimate, non-discriminatory interests, and then that burden would shift back to the plaintiff to establish that those interests could be served by another practice that's less discriminatory. But under the proposed rule, next slide. Under the proposed rule, the defendant, once the plaintiff establishes those 5 requirements, which again is a pretty hefty hurdle for plaintiffs to have to establish. The defendant would have a defense if they can show any of the things listed here. And any of these things would be a complete defense. So the defendant could show that its discretion is limited by a federal, state, or local law, and that would be a complete defense. Or they could show that the challenge is really based on an algorithm. And then if they can demonstrate that the input for that model and the inputs are not proxies for protected classes, then that would be a complete defense. Sorry, go back. Okay. If they can show that the algorithm is maintained by a third party and that it's used by the industry, that would be a complete defense. And so think about how algorithms are really playing a bigger and larger role in our lives and in this industry. And the fact that a defendant could simply point to the use of an algorithm and that would be a defense to a discrimination claim. Or if they say that the algorithm has been reviewed and approved by a third party as being statistically sound and empirically derived, and none of the inputs are proxies for protected classes, then that would be a complete defense. Next slide. So you have an algorithmic defense, a defense if they say they were relying on a state or federal law, and of course a defense if they are able to show that the plaintiff has not met, again, that very high hurdle of 5 requirements to establish a prima facie case. Those would be the complete defenses. But those are not the only defenses afforded a defendant in this proposed rule. A defendant could also establish a defense that if they can demonstrate that the challenged policy or practice serves a valid and legitimate interest. That would not be a complete defense. That would cause the burden to shift back to the plaintiff to show that the valid interest can be met by an alternative policy. But again, we see a higher sort of burden or barrier for plaintiffs because in addition to showing that it could be met by an alternative policy, they have to be able to demonstrate, the plaintiff has to show that that alternative policy would not impose greater cost on the defendant and that it would not create other material burdens on the defendant. So again, we see a huge burden placed on the plaintiff and multiple defenses allotted to defendants. And then I'll say the other defense would be to demonstrate, or other requirement would be to demonstrate that it equally serves the government interest. And I think that was the end of the comparative slides, but I would just say that overall, what we see with this proposed rule, again, is the effective elimination of the ability for HUD to use the disparate impact standard to combat discrimination, which we feel is pretty clearly juxtaposed against the mission of what HUD is supposed to be advancing. I just also want to lift up or reiterate what Leslie shared in terms of what the Supreme Court case actually said. It very clearly upheld that the disparate impact standard and claims are consistent with the Fair Housing Act's central purpose. Justice Kennedy talked about in the decision, talks about the idea that disparate impact liability provides an appropriate and important means for defendants to state and explain the valid interest served by their policies. When he makes that statement, he's talking about what is embodied in the current rule. So in effect, he's saying the current rule adequately meets the defendant's need to be able to demonstrate that their interest is served by the policies. And that the burden shifting framework, again, that which is embodied in the current rule and is supported by decades of case law, is what's consistent. So the burden shifting framework that's in the current rule is consistent with the existing case law. This proposed rule by HUD flips that framework entirely on its head. It discards years, decades of case law. It discards the Supreme Court's ruling just 4 years ago. And we should all be concerned and in arms about what's being proposed. I also want to just share that this is, while we're talking about it within the housing context today, as Eva shared, this is part of a broader effort to really do away with the disparate impact standard, which is used across the board. So housing, employment, a number of different contexts. And so even if you are not someone who is deeply involved in housing or concerned about housing, you should be concerned about what we're seeing in this rule, because it is part and parcel of a larger effort to, as Eva said, do away with or undermine disparate impact and replace it with intent. As I close, I just want to read a passage again from Justice Kennedy. Much progress remains to be made in our nation's struggle against racial isolation. In striving to achieve our historic commitment to creating an integrated society, we must remain wary of policies that reduce homeowners to nothing more than their race. But since the passage of the Fair Housing Act in 1968, and against the backdrop of disparate impact liability in nearly every jurisdiction, many cities have become more diverse. The Fair Housing Act must play an important part in avoiding the Kerner Commission's grim prophecy that our nation is moving toward two societies, one Black, one white, separate, and unequal. And with that, I'm going to turn it over to my colleague, Sandra Park, to talk about how this proposed rule will specifically impact women.
Thank you. And I want to give thanks to Janelle and the ABA Civil Rights and Social Justice section, and also to all my co-panelists. I'm really honored to be part of this discussion. Again, my name is Sandra Park. I am an attorney in the ACLU Women's Rights Project, which is part of the national office. And my area of focus for the last 12 years here has been advancing the rights of survivors of gender-based violence in a variety of contexts. And we long ago prioritized housing as one of the main areas that was a focus for survivors of domestic violence and sexual assault. If you look at surveys that come out nationally on what survivors need, consistently, access to stable housing is identified as the #1 need for ensuring long-term safety and security for domestic violence as well as sexual assault survivors. And one thing that we have found also in these studies is that survivors are at increased risk of eviction and loss of housing because of the abuse that they experience. And as such, we have really focused on challenging forms of housing discrimination that essentially blame survivors for the fact that they are experiencing violence. And the Fair Housing Act has been a critical tool for us on that front. And that is why the ACLU, the Women's Rights Project, as well as our Racial Justice Program and other parts of the ACLU are standing strong in opposing the proposed rule. I want to talk a little bit about how we've used the disparate impact standard, the current disparate impact standard, to challenge housing discrimination experienced by survivors. It has been a really vital tool, in part because our statutory framework that governs housing rights for domestic violence survivors is a bit of a patchwork. So at the federal level, we may have the Violence Against Women Act, which only applies to federally subsidized housing and protects housing for survivors. But again, that is only for certain recipients of federally subsidized housing. In some states, there are state laws that protect the housing rights of survivors. But again, that is not consistent across the states. And many states do not have those kinds of laws. And so survivors have no access to legal protections in those states if that's one of the states where they live. And so long before the states even began legislating in this arena, and long before the Violence Against Women Act was enacted, advocates were using the Fair Housing Act, and we were using the disparate impact standard to advance the housing rights of survivors. And the Fair Housing Act, of course, is vitally important because it applies to all housing providers, both private landlords and housing providers as well as government-funded ones. And so in many ways, in many contexts, it provides the most comprehensive federal housing protections. So, the Fair Housing Act, of course, within it, domestic violence or sexual assault, the experiencing of those crimes is not a protected class. But there have been many claims that have been successfully brought against housing providers who denied people housing based on their status as a survivor. And one of the main ways that's been done is arguing that sex discrimination protections within the Fair Housing Act apply to domestic violence. And so one of the first cases that actually was brought in this arena is called Avera versus CBM Group, and I've listed it up on the slide. And basically what happened there was Ms. Alvera faced eviction after her husband assaulted her in her home. And even after obtaining a protective order and after her husband was arrested, she got a notice of eviction from her landlord. And basically what it said is, okay, a crime occurred in your home. You're responsible for that. You are facing eviction now. And what Ms. Alvera did is file a complaint with HUD, and HUD charged discrimination in part on the disparate impact theory that if you have a policy of holding victims of domestic violence responsible for crimes in their home, that will have a disparate impact on women because we know that the vast majority of domestic violence survivors are women. And so that was a charge of discrimination that came out, and that DOJ then brought a first lawsuit back in 2001, litigating that case under the Fair Housing Act. And the ACLU Women's Rights Project represented Ms. Alvera as an intervener in that case, which resulted in a very successful settlement and consent decree. And that was a model for a lot of the litigation that followed, where again and again we saw landlords and housing providers blaming and trying to evict survivors of domestic violence because of the abuse they suffered, because of property damage caused by their abusers. And the Fair Housing Act was and has been a vital legal tool in intervening in those types of situations. I also wanted to mention that HUD itself has recognized the importance of disparate impact in protecting the housing rights of survivors of domestic violence. It issued guidance back in 2011 that talks about the Fair Housing Act as a legal protection. It talks about it both in the context of disparate treatment claims and disparate impact claims. And then also back in 2016, there was guidance issued on how the Fair Housing Act, both in terms of disparate treatment, where we're talking about intentional discrimination, as well as disparate impact, can help protect the housing rights of survivors of domestic violence and other crimes who are blamed under local laws for reaching out to the police. And oftentimes those local laws are called nuisance laws. So both of those memos have been really important tools that advocates across the country have been able to use to protect the housing of survivors. And oftentimes we rely on sex-based arguments, but there also can be disparate impact arguments based on race and national origin, depending on the context in which we're talking about. So I have listed here some of the types of policies and practices that have been challenged. For example, one-strike policies, basically where a landlord might say, you get one strike, so if any crime occurs in your home, the entire household must be evicted. And those have been very common in many parts of the country. There are other types of policies we've seen where there are screening policies. So landlords are screening applicants and might become aware that applicants are domestic violence survivors. For example, if applicants are coming from domestic violence shelters, and then choosing to say, well, I don't want to rent to folks who are coming from domestic violence shelters because they're survivors. That type of policy is neutral on its face in that the landlord is not saying, okay, I'm denying housing to women, but a policy that denies housing to domestic violence survivors clearly has that type of disparate impact we're talking about on women. And then I also mentioned nuisance or other local laws that are prevalent around the country that punish tenants for calls for police or emergency services. They might set numerical limits for how many times a household can call before the city would then pressure the landlord to evict that household. And the Fair Housing Act has been very important, and HUD has used the Fair Housing Act to try to address those types of situations. Connecting it to what Lisa talked about in terms of the proposed rule, because the standard is so high under the proposed rule, you can imagine that in a lot of scenarios, landlords will offer justifications that might be considered to, meet the valid and legitimate interest standard. So, for example, a landlord who has a policy of screening out domestic violence survivors might argue that, well, it's simply less costly for us to less costly if we choose not to rent to domestic violence survivors because we don't know what could happen as a result of renting to them. And that's often a very stereotypical and speculative way that landlords think in terms of their concerns about renting to survivors. But you could imagine that type of justification being offered. And, because cost is such a key criteria for whether or not a plaintiff can successfully bring a disparate impact claim under the proposed rule, I think that will be a very difficult burden for a lot of plaintiffs to meet if the landlord can make some sort of colorable argument that this saves them money. And so we are really concerned that this proposed rule will have an impact on severely undermining the rights of survivors. I focused here on the rights of survivors, but we also know that the proposed rule will impact women more generally. Leslie talked a little bit about the issue of occupancy requirements, which we see having a heavy burden on women with children, depending on how occupancy requirements are imposed. Oftentimes they are overly restrictive and deny housing for women with children. We've also been concerned about discriminatory mortgage lending policies, where banks may say that they will not give mortgages to folks who are on paid leave, even though they are receiving income during that period of time. That kind of policy, of course, would have a disparate impact on women who are more likely to take paid parental leave, at least for longer periods of time than men, and may disqualify them from mortgages that they otherwise should be considered qualified for. So I think I'm going to wrap up here, but I wanted to just highlight the concerns that the gender justice community has about this proposed rule. And we've been working with many other groups, including the National Women's Law Center, to really encourage folks who are maybe coming at this from a gender justice focus to join us in expressing concerns about the rule because of its widespread impact. So with that, I'm going to turn it over to Jennifer Mathis from the Bazelon Center.
Thank you. This is Jennifer. I am the Director of Policy and Legal Advocacy at the Bazelon Center for Mental Health Law, and I very much appreciate the privilege of being part of this panel. Like the other organizations represented on this panel, the Bazelon Center opposes the proposed rule that would effectively eviscerate disparate impact liability under the Fair Housing Act. Housing has been, I think, one of the top priorities of the disability community. Sandra mentioned its tremendous importance of stable housing for survivors of gender-based violence, and very similarly for people with disabilities. Affordable and accessible housing has been key, and the need for it has been one of the biggest barriers to people with disabilities living in their own homes and communities. People with disabilities are twice as likely, working age people with disabilities are twice as likely to be living in poverty as people without disabilities. Also, given their needs for accessibility, the ability to get affordable and accessible housing has left many people with disabilities homeless or stuck in institutional settings. and the need to preserve all the tools to address discrimination in housing, therefore, is really critical for people with disabilities. So I want to talk a little bit about some examples of how disparate impact protections have applied to protect people with disabilities. Many people, I think, have seen some of the cases that have been brought with disparate impact claims under the Fair Housing Act, and there's a lot of zoning cases that have been brought around group homes for people with disabilities being zoned out. I think that's what a lot of people think about when they think of disparate impact liability based on disability discrimination in housing. Some of that has changed over time as disability service settings have evolved over the years, so that there is less focus on group homes and congregate living, and people with disabilities are more often seeking to live in their own homes and apartments. But that is by far not the only type of disparate impact claim that people with disabilities brought in the context of housing. There are many other types of disparate impact claims that have been very important to people with disabilities. So, for example, there have been requirements imposed by both public housing and private landlords that tenants of housing be able to live independently. One of the cases where this was discussed is Quezon versus Rochester Housing Authority. This was back in 1990, actually. There have been other cases that have been brought challenging very similar requirements. I just want to give an idea of what that case was about. That was 3 individuals with physical disabilities, in some cases mental disabilities, in some cases excluded from applying for public housing because of their disabilities and the sense that they might be dangerous because they couldn't live independently. One of them, for example, was a woman with a psychiatric disability, and the basis of denying her housing in public housing was that she needed support services. She had been hospitalized. She had felt depressed at times. She was bothered by noises. She had questionable hygiene habits, and needed a lot of services. And therefore, she was considered not to be able to live independently. Those tenants won that case in Quezon, and that type of requirement has been challenged by many other folks with disabilities successfully using the disparate impact protection. There have been disparate impact claims brought by people with disabilities challenging different types of requirements that are effectively source of income requirements. For example, requirements that tenants have a job and not receive their income from disability benefits or other benefits. Give one example here: Connecticut Fair Housing Center versus Rosso, which was settled in 2013. There have been prohibitions or restrictions on tenants receiving housing subsidies. Other folks raised that issue as well. That has been the subject of disparate impact challenges brought by people with disabilities. For example, LC versus LEFRAC organization out of New York in 2013 was a case brought by people with HIV/AIDS who were made to go through a separate and onerous process to apply for housing because they had housing subsidies that were essentially for people with HIV/AIDS. If we could move to the next slide, that'd be great. Disparate impact claims have also been brought by people with disabilities, a variety of other contexts. Actually, minimum income requirements. The case I list is actually a case of racial disparate impact, but similar claims can be brought by people with disabilities, have been brought by people with disabilities. In this case, Bronson versus Crestwood Lakes, Section 1 holding corporation involved a landlord's requirement that tenants had to have income that was 3 times the amount of the rent. Again, people with disabilities are overwhelmingly sort of poor compared to, I think, many other segments of society, and would be disparately impacted by those types of minimum income requirements. Refusal to accept papers from a conservator. People have been denied housing on the basis that they have a conservator or a guardian who is helping them fill out an application, and a landlord says you can't do that. That has been challenged using disparate impact. I mentioned application of zoning restrictions is less of a popular type of challenge now than it was maybe 10 years ago, but there are still certainly plenty of zoning restrictions that people with disabilities do continue to have concerns about, do continue to challenge. I listed a case here, Sharp Visions versus Borough of Plum, which was about an individual person with mental and physical disabilities who was denied the opportunity to live in a house by the Borough of Plum because they considered his house a group home, even though it was one person, and they said it violated the zoning ordinance. He had a house that was bought by a service provider, purchased for him to live in, and so therefore that was considered a group home, and he was denied the ability to live there and successfully brought a disparate impact challenge. There are other types of requirements as well that have been problematic for people with disabilities. Overbroad criminal background checks. HUD actually issued a guidance in, I think it was 2016, about how overbroad criminal background checks could be could have a disparate impact based on race and national origin. Similarly, given particularly the overrepresentation of people with psychiatric disabilities and the population of folks who are incarcerated, those types of overbroad background checks can also have a disparate impact based on disability. Minimum credit score requirements are another one. So those are some. There are many, many other types of situations where people with disabilities have been excluded and have been able to successfully challenge barriers to housing using disparate impact liability. I should mention quickly that under the Fair Housing Act, as under the ADA and Section 504 of the Rehab Act, there are sometimes reasonable accommodation claims that can also be brought. So folks should know that those types of claims are out there and may apply in similar circumstances, in some cases, to disparate impact type claims or situations where disparate impact may also apply. But disparate impact has been a very important tool for addressing many types of disability discrimination, and we certainly don't want to see it eviscerated. And I'm going to turn it back over to Eva.
Well, my fellow panelists, you all are rock stars, and I've learned so much, and it's also very interesting that we're all women, just coincidentally. What I think we understand is that part of what we are all doing is try to deal with making that more perfect union that we've talked about as a country. And we're fighting racism, misogyny, discrimination against people with disabilities. We also talked today about the fact that the disparate impact standard flows from some of the Title VII litigation. And you might know that I believe people like Clarence Thomas would like to eliminate disparate impact in Title VII. So Lisa's exactly right. We must be alert for what's going on. Disparate impact has been a tool to put forward the desegregation of housing. And we also must realize that the right wing wants to take away disparate impact and replace it with intent. In the 2015 Texas case, Justice Kennedy saved us. I think they thought he was going to go with the conservative 4. One of the things that I think that Leslie pointed out that's very important to understand is that Justice Kennedy bought into the notion that unconscious bias or implicit bias might be a motivating factor in why discrimination happens. Most people in society, at least until the last 2 years, weren't proud of being racist and didn't want to be racist, and it was very difficult to show that overt racism was the reason for bad decisions. Housing discrimination is alive and well. Leslie really pointed that out. It's important to understand why desegregated housing is so important. Where you live affects all kinds of things. It affects the kind of schools your kids go to. It affects whether or not it's easy for you to get to a place of employment. I've read studies about people who wanted to get a job, but their housing was so far away from the employer, they just couldn't do it at all. So disparate impact remains a tool for that. I found it very fascinating to listen to Lisa's remarks about the HUD regs. It's like we have 5 hurdles to get over, and the defendants have 1 hurdle to get over. These whole proposals are weighted towards serving business and corporate interest. I may be dating myself by using this analogy, but it sounds like we're like Ginger Rogers dancing with Fred Astaire. He's just moving forward, and we've got to do the same thing going backwards in heels in order to make out our claim. That may be too dated of a reference from some of you. Sandra, I was so fascinated to hear from you and was thinking that I believe the notorious RBG founded the ACLU Women's Rights Project, so you are in a great historical flow. I found it so interesting to hear how women who are survivors of domestic violence encounter housing discrimination. One of the first cases I worked on in 1975 when I was a baby lawyer involved women in East Oakland who were being beaten, but they couldn't leave their homes because they had no housing. So it's very important that your organization is moving forward, because you will actually be saving people's lives if they have a place to go. I also find it very interesting, and I'm speaking now only for myself and not the ABA, but and Janelle's going, oh my God. I understand there may be HUD employees watching and listening. If you're out there, do the right thing. Your agency is supposed to be desegregating housing, so do everything you can to do that mission, because it sounds like it's very clear that HUD has been very instrumental in making sure that discrimination is not alive and well. I found it fascinating, and I hadn't thought about this, Jennifer, that people with disabilities are affected by housing discrimination. I hadn't thought about that at all. So thank you very much for enlightening me on that. To go back full circle, we are all committed to having a society where discrimination and bias are not impacting people's life choices. The disparate impact is a way to make sure that housing, the disparate impact standard is a way to make sure that housing remains desegregated or gets desegregated. So we very much resist this move on the part of HUD to make it more difficult for people to live in desegregated housing. And we urge everyone out there listening to be engaged in any way you can in resisting these attempts by HUD to resegregate society. So I will turn it back over to Janelle, and I hope I haven't harmed the ABA.
Thank you so much, Eva, and thanks to all of our panelists. Before we go to questions and answers, and again, you can input your question. We have a few right now, but you can input your question by typing. If you click on in your menu, drop-down menu, the questions bar. We want to share a couple of resources for those who would like additional information. The first one is actually listed on the bottom of this slide. defendcivilrights.org is a website. It's a home site of a campaign focused on protecting disparate impact. It's led by the National Fair Housing Alliance, the NAACP Legal Defense and Educational Fund, the Lawyers Committee for Civil Rights Under the Law, the Poverty and Race Research Action Council, the American Civil Liberties Union, and the Center for Responsible Lending. So if you access this website, what you can find is guidance and information about writing a comment letter for those who are interested in commenting, and also more background information on disparate impact and housing as well. And also for those, you also see the link to the Federal Register if you want to read the proposed rule in detail, and you can also submit your comment online here. resources for writing comment letters. This is particularly for those who have not written comment letters before. There are really great resources and guides, including from regulations.gov, a great resource on tips for submitting effective comment letters, including making sure that you incorporate your personal experience in your comment letter. So even if you want to, we took this poll at the beginning of the webinar. If you want to incorporate your experience, what you're learning as a law student, what you're seeing as a practicing lawyer, some of the real life examples that you've seen firsthand, if you want to incorporate that in your comment letter, this guide really suggests adding in your personal experience and perspective. The Brookings Institute has a great guide, and you'll see some links to some other resources here. And again, you can submit your comment via the Federal Register, and defendecivilrights.org also has a link where you can comment. So why don't we go to, and again, encourage folks to type in your questions. We do have one a question. Why don't we start with this question? This is more for, I think, Leslie and Lisa, and for other panelists who are interested in jumping in. Can someone speak more to HUD's statutory mandate, its requirement that it affirmatively further fair housing, and how this rule is going in the opposite direction in possible violation of HUD's statutory duty? So I would hand that to Lisa, Leslie, and anyone else who's interested in addressing that question.
Sure, thanks, Janelle. I'll jump in, and Leslie, please jump in. So the duty to affirmatively further fair housing is embodied in the Fair Housing Act. That duty has been part of the Fair Housing Act since 1968. There is actually a HUD rule regarding that duty that is also under attack. But that responsibility, that duty places on HUD a responsibility to proactively engage in fostering communities that are free from discrimination, to take meaningful action, I think was the exact language, to combat discrimination, to overcome patterns of segregation, and again, to foster communities free from barriers that restrict access to opportunity. So thinking about how you proactively ensure that where folks live, back to Eva's point about where folks live matters in terms of their access to quality education, their access to transportation and to gainful employment. All of that is part of the duty to affirmatively further fair housing. And so if you think about this proposed rule and sort of the way that it is antithetical to addressing discrimination, I mentioned earlier that it really is almost directly in opposition to what HUD's stated mission is. In the same way, it is almost directly in opposition to that duty to affirmatively further fair housing. And Leslie, I don't know if you would add anything to that. I'll just tee up, and maybe we'll have another webinar, but that the AFFH rule is under attack, and it's another important tool that is under attack, and an important tool to ensuring that folks have equal access to opportunity.
Yeah, that's exactly right, Lisa. This is really the 1-2 punch by the Trump administration against the tools to promote integration and to eliminate discrimination. These are two separate obligations under the Fair Housing Act: to not discriminate, which is, disparate impact falls under that, and then also to actually affirmatively promote integration. And the Trump administration is weakening both severely. And so they work together, they should be working together under the Act to promote residential integration. And the Trump administration has both in their sights as decreasing our ability to promote fair housing.
Thank you. Thank you both. This next question, I think, is more for Jennifer. Jennifer, you spoke about the impact, disparate impact, and its importance for individuals with disabilities. Is it clear that reasonable accommodations are required even without disparate impact?
Well, yes, I think there are certainly those are two separate obligations in the law. I think that reasonable accommodation claims may still be available. There's just some overlap between those two types of claims, and there are some situations that lend themselves to both types of claims. But reasonable accommodation claims may still be available even if disparate impact claims become virtually impossible to bring. But that is not to say that every type of situation is necessarily something that can be addressed through a reasonable accommodation claim. So yes, I'm not sure that what might happen to the disparate impact rule if this proposed rule were to be adopted would also take away reasonable accommodation claims. I don't think it would. I wanted to make sure folks were aware that that avenue may be available for some people, but we need all of the tools that we can get, essentially, and we can't afford to lose any tools. And so, there certainly are situations that may not be amenable to reasonable accommodation claims as well that should be addressed through disparate impact.
Thank you, Jennifer. This next question seems targeted towards Leslie and Lisa again, but again, if others want to jump in. The Inclusive Communities case upheld disparate impact, but emphasized a robust causality requirement. In your view, how does that change the causation element of a disparate impact analysis, if at all? And do you think it makes disparate impact less potent as an administrative enforcement tool, even under a different administration?
Well, the questioner is absolutely right. Justice Kennedy did talk about robust causality. And, this isn't a new concept. As Lisa talked about with the final regulation that the Obama administration issued, you have to have some causality. I mean, it's a principle of anti-discrimination law that you have to show that the practice was the thing that disproportionately impacted the protected class. Justice Kennedy did discuss this, and there are certainly questions about how this is going to be interpreted by the court if in fact it's something new. But I want to say this: it would be one thing if HUD were to take that ICP, as we call it, decision, and say we want to interpret this. We want to ask for public comment on what this should mean under the Fair Housing Act, and that would be something that perhaps would be expected. But that is not what HUD did. HUD went way past anything that the Supreme Court may have asked or may have put out there about some sort of new requirement, and added, as Lisa talked about, these almost insurmountable barriers for proving discrimination. And so, it's almost as if it's a solution in search of a problem. And I think the causality issue is something that's going to be litigated. It already is, frankly, being litigated, but it certainly should have not have prompted this proposed rule from this administration.
Thank you. Leslie, anything, Lisa, to add to that?
No, I think Leslie addressed it.
And so this next question seems, I'll just open this up to all the panelists. How should individuals and organizations best make their objections to the proposed or the proposed changes to the rule? How should they best respond? And is it best to comment individually or as a representative or as an organization?
Well, I'll take a stab. I'm sure others can chime in. You know, it is fine to comment however you'd like to. You can send an individual comment. In fact, the link that you post, defendcivilrights.org, is something that the civil rights organizations have posted, and it makes it very easy for individuals to file comments. All you do is fill out the prompts. On the other hand, if you're with an organization and want to provide a more substantive analysis of what this will do to the communities that you serve, it's fine to file an organizational comment too. As far as individuals or sign-ons, it doesn't really matter. The idea is to just let HUD know that this is a terrible rule and that they should withdraw it.
I have something to say, if I can. Do whatever Leslie says. She's exactly right, and she's totally on it. But here's another perspective. Somebody sent me something within the last year. They said, if you want to know what you would have done in Nazi Germany or during slavery, look at what you're doing now. And the society is being resegregated bit by bit by bit by bit. And it's making a lot of people really crazy. What can I do? I'm so depressed. Well, you can do something. You can let your friends and neighbors know about this. Leslie has outlined a very simple thing that people can do. The people at HUD, from what I can understand, they pay attention to the comments. So if what you're seeing around you as Rome is burning is bothering you, this is something concrete that you can do and that you can urge your friends to do, because they're attacking us on every front, and they're hoping that we will get tired, but we can't. So this is a simple thing that you can do. Please do it.
And this is
Not
Jennifer. I would just
the
add,
ABA. Sorry.
This is Jennifer. I would just add that, you know, perhaps maybe more important than whether you submit a comment as an individual or as a group, is sort of that you include some concrete examples, some reasoning, you know, behind sort of why you have concerns about the rule, rather than just simply saying, I oppose, this is a problem.
Agree.
Great. And again, we have some resources about writing effective comment letters that are available as well via these links. Another question I'll open up as well is anyone aware of any hearings related to the proposed rule?
The Equal Justice Society is thinking about having a tribunal in Oakland on October 19th to take testimony from people as to how the current administration is harming people of color. And so we would love, I hope Leslie can come. I'm not going to put you on the spot, but I know you like to come to the Bay Area. But we'd like to have people testify about how this proposed reg will harm people of color. We're going to have people coming talking about the babies in cages, the attempt to rig the census. So we would love to have somebody who is up to speed on this issue come and talk about how, if this reg is passed, it will concretely hurt people of color. So stay tuned.
Okay. And does anyone know of plans by any other agencies to amend regulations or policies regarding disparate impact?
Well, there were a series of articles in the beginning of this year that telegraphed the Trump administration plan to mount a broad-based attack on disparate impact. There was in the Washington Post, there was a New York Times editorial, there was something in the Atlantic, and they were documenting, you know, internal memoranda talking about this. This is something that's definitely in their sights. We already saw the Department of Education withdraw the school discipline guidance, with Janelle, I know you know that very well. That was something that they could do because it was a guidance. They could do it unilaterally. So there was no provision for public comment. That guidance was talking about the disparities, the disproportionate impact that school discipline policies have on children of color. So disparate impact very much was central to that guidance, and they withdrew it. Now we have the HUD reg that is being proposed, and frankly, we expect more. They have said they're going to do more, and we expect more. So it's very important now that everybody weigh in on this, because it's HUD today, but it's going to be another issue tomorrow.
And this is Jennifer. I would just add that in the Department of Education School Safety Commission report, they also made some statements about disparate impact, liability in the context of education, and expressed some discomfort and suggestions that that rule might be revisited.
And this is Lisa. I'll just add that in addition to the articles or reports that Leslie mentioned, there was an article when the rule was actually posted in the Wall Street Journal that specifically reported that the Justice Department has discussed or is discussing rewriting anti-discrimination regulations to remove the document the doctrine so that no federal agency can use it. So again, this is coming. It's coming soon to all of the federal agencies, and it warrants everyone getting involved at this stage.
Thank you. One last technical question before we wrap. Is there guidance on what the robust causal link means under element 2 of the proposed rule?
Well, I guess I would say all the guidance we have right now is in the proposed rule. That's the extent of HUD's analysis. And I think one of the problems with this is we don't know what they're thinking with some of this. Some of it, we know exactly what they're trying to do. Other things we don't know. And so I expect that some of the comments that HUD will get will be precisely asking questions. How do you define this? What does this apply to? Are these cases effectively prohibited now? And so I think, if you have questions about this, you should ask HUD what they mean.
Thank you all so much again. And I just want to emphasize before we officially wrap up this webinar that the Civil Rights and Social Justice section has for more than 5 decades worked on hundreds of issues addressing a broad range of civil rights, civil liberties, and international human rights issues. And the section continues to promote policies affecting religious freedom, LGBTQ rights, gender equity, and other significant civil rights issues. So please consider making a donation to support the section, and you can go to americanbar.org/CRSJ for Civil Rights and Social Justice. And your gift will help us to continue these efforts for decades to come. And I do want to read another comment that someone submitted saying, thank you to each presenter for sharing your expertise and time. The many aspects of housing and employment that are affected by disparate impact are vital to equality in each sector. Thank you for providing historical context, Eva Patterson, and thank you to each of you for reminding us how important the endeavor is to keep the statistical component as opposed to intent is in these cases. So thanks again so much to all of our panelists. And again, if you have any questions, please feel free to follow up with us. And use the resources provided by the Civil Rights and Social Justice section. Thanks so much for your time and your attention and consideration of these issues. I see that most of the attendees have hung in with us. So thanks so much, and thank you again to our panelists.
Thank you.
Thank you, everyone.
Stay strong.
Mhm.